Welcome, welcome, welcome to all honored guests. I am so glad that you're joining us today. Today, we are having our second community conversation event honoring Black History Month. My name is Daniela Mendez, and I serve as the Director of Campus Administration at the Tampa Bay campus. Black History Month honors all people from all periods of U.S. history. Black History Month is, in fact, American history. First, it is my honor to introduce President and Dean James McGrath to give opening remarks.
Thank you, Daniela. As Daniela just mentioned, Black History Month honors the immeasurable contributions of Black Americans and celebrates the rich cultural heritage, triumphs, and adversities that are an indelible part of our country's history. I'd like to thank Director Daniela Mendez for her work in putting this all together. Big hearty thank you and welcome to Dr. Ponton for taking the time to discuss his work on race and society yesterday and today. And finally, thanks to Professor Jocelyn Hardrick for her willingness to moderate the discussion and question and answer period following Dr. Ponton's remarks. And of course, thank all of you for attending today and taking time to continue to learn and grow, which is so important for everybody, but especially for our lawyers in training. As lawyers, you'll be lifetime learners, so I honor your inquisitiveness as we celebrate Black History Month. I really look forward to this community conversation. So with that, back to you, Daniela, to get us started.
Thank you, President and Dean McGrath. A couple of things before we introduce our amazing guest speaker, Dr. David Ponton, today. We ask that all participants please remain on mute during the presentation. Dr. Ponton will speak for approximately 40 minutes or 45, however it goes. And at the end of the presentation, as President and Dean McGrath mentioned, Professor Jocelyn Hardrick will lead our Q&A session. Having said that, please feel free to write your questions in the chat, and hopefully there's enough time she will get to ask all of them. Now, all the part that we've been waiting for. Dr. David Ponton is a trained historian and an assistant professor in the School of Interdisciplinary Global Studies at the University of South Florida, Go Bulls. He hails from a working class family in Trenton, New Jersey, and is a first-generation college graduate. He received his bachelor's degree from Princeton University with a concentration in religious studies and certification in African American studies. Simultaneously, he completed studies in teaching and learning and was certified to teach grades 6 through 12 social studies. He taught at Ewing High School in New Jersey for 3 years before matriculating to Rice University for graduate school. At Rice, Dr. Ponton received his master's and doctorate degrees in history. In both research and teaching, Dr. Ponton's work concerns the significance of anti-Black racism in the history and the present, and his archival research is centered on housing segregation and its relationships to educational segregation, criminalization, gender and sexuality, philosophy, and social psychology. He has published in venues such as Theory and Events and Frontiers, a journal of women's studies, and has forthcoming articles in History and Theory and Key Parlay concerning Afropessimism, challenge to the historical discipline. His book project, Decades of Capture, The Permanence of Segregation in Postwar America, is under contract with the University of Texas Press. Welcome to the stage, Dr. Ponton.
Thank you so much for the introduction. Thank you all at Cooley for having me here. Very excited. I also like to shout out Daniela for your help putting this together. The talk I prepared is going to take about 45 minutes, so I'm going to try to jump right into it so that we have some time towards the end for more conversation. So let me share my screen with you. And if I can just get a thumbs up that that looks fine on your end. Great, thank you. So the pessimism and promise of Black history. In April of 1953, a man by the name of Carl Davis ignited 4 sticks of dynamite on the front porch of Jack and Dorothy Caesar's home. Since the Caesars had moved into the Riverside neighborhood just south of Houston's 3rd Ward, in 1952, white residents had been fighting to return the neighborhood to a white-only residential enclave. Aside from an incident on New Year's Eve when the Caesars roof was littered with fireworks, the family lived without physical attacks on their property until this bombing. According to 51-year-old Davis, George Howell, 56-year-old insurance company owner and vice president of the Homeowners Association, had been hiring him for various jobs for about 3 weeks. Howell, an ex-convict who had been in federal prison for committing fraud, called Davis, also an ex-convict with a 5-year suspended sentence for attempted murder, into his office one afternoon and instructed him, "I want you to blast that nigger house across the street for $500. 3 weeks prior to the attack on the Caesars home, Davis went to Rosenberg, Texas to buy dynamite. He turned over the material to Howell, who prepared the 4 sticks for detonation. Then on the week of the 12th of April, Howell announced that he was ready to go through with the plan. And on April 16th, Davis left his room at the Standard Hotel in downtown Houston, caught a bus toward Riverside, and then slept in the backseat of a car until about 4 a.m. He explained, "I took the dynamite out of the car and walked across the street from the Howell's house to the nigger's house. I stopped on the steps of the nigger's house and lit the fuse. I set the dynamite near the pillar and walked off." Fortunately, the Caesars were physically unharmed, and Davis was sentenced 2 years for his crime. Howell was never convicted. Today, I want to talk a bit about dreams, the dreams of Black folks. But over time, I've come to a sobering realization about dreaming as Black under America's liberal democracy. Our dreams seem to yield nightmares. The Caesars had done everything they were supposed to do. They had built wealth in a capitalist society. They had used their economic resources to try to secure what they imagined would be a better life for their family. However, their dreams were incommensurate with their political condition. They remained incarcerated by race. Their story provides us a critical perspective from which to engage the narrative art form that we call history. As a historian who yearns most of all to be honest, I have to admit something that few in my profession are willing to, that histories are not factual representations of the past. Rather, histories are the stories we tell, and in doing so, we invent the past as historians. And some might argue that we are a social science, that our methods are testable, and that we cannot make up stories whole cloth, that, of course, we must have evidence from what we call the archive. And sure, we have methods and we cite our sources, but we approach these sources as they have already been mediated by the folks who created them. And they're mediated again by our own socialization in the here and now. Moreover, we don't see the past in these documents. Rather, they provide impressions. We must always marshal our imaginations in order to narrate stories about the past, and we do so with intentions, both conscious and subconscious. Here's an example. I just told you that the Caesars were physically unharmed by the bombing, but that's conjecture. The source that I had was from Jet Magazine's April 1953 issue, and it says no one was injured. But neither what I said nor what the source said can be true. Anyone with a bit of empathy can know that. While the Caesars may not have been in the dynamite's blast zone, they suffered from a lack of sleep that night and chronic stress and anxiety from all of the terror they had endured since they moved into this home. These should count as physical harm, since we know that chronic stress can lead to heart problems, diabetes, inflammation, and depression. To claim that they were unharmed is to invent a certain kind of past, and I think in this case to write a lie. While this kind of matter-of-fact treatment about the past is common practice among historians, it is not what I would call Black history. Thus, what I'm presenting to you today as a historian is an argument, and a sound one I hope, about the potential of what I would call, and perhaps what we can call, Black history. I wrote 3 versions of this talk, and the first 2 barely resemble this one. At first, I thought I might tell you a series of related stories about housing discrimination and the varied ways Black people have resisted it over time. But these are stories you can read for yourselves. You're legal practitioners and legal students and scholars, so you don't need me to do that for you. But Nathan Connolly's A World More Concrete about South Florida, Kevin Cruz's White Flight about Atlanta, Joe Trotter and Jared Day's Race and Renaissance about Pittsburgh, and Tom Sugrew's Origins of the Urban Crisis about Detroit are a few examples. But these stories are just as much about white people as they are about Black people, and just as much about America as they are about African Americans. And so I don't think Black history is merely history, but specifically about Black people, because Black is much more than a color or an identity. It's an imposition created in history, and in the history of racial slavery in particular, to designate what kinds of people were outside of the European concept of humanity. That is, Blackness indicates a position within a structure. And so Black history is not the story of a people per se, but it's the analysis of a racial anti-Black structure and a critical stance toward history itself as a tool that maintains that structure. What do I mean by a critical stance toward history? If we write that the Caesars weren't harmed, we invent a past where anti-Black violence has no effect. We erase the Caesars who existed and create new ones in our imaginations. These Caesars impervious to fear, pain, hurt, or loss. In this way, history appears to present a simple fact when it is in fact inventing narrative. And oftentimes these narratives, though they may seem benign, can erase Black subjectivity. That's why I believe Black history has to do different work. Thus, I tell the Caesar story not to provide facts about the past, but to open up questions about the ideas that we often take for granted, especially because a good deal of the Caesar story had to do with two domains where Black people have historically sought refuge from American terrorism: property ownership and the law. As a researcher and a theorist, I asked three questions. Did the Supreme Court's 1948 decision in Shelley v. Kramer, which allowed the Caesars to buy their home in this formerly white-only deed-restricted neighborhood, change the structural position of Black people in America? Does the law present opportunities to realize a more perfect democracy than the democracy Black Americans have suffered for the life of this nation? Does liberalism and its tenet of abstract equality have the capacity to make us all equal? And I won't bury the lead here. My answer to all of these questions is unfortunately a no. And compelling us to accept the implications of an answer like that, I believe, is the mission of Black history. Black history should destabilize our faith in the world that is and its promises without foreclosing our imagination concerning what could be. So I'm going to proceed in three parts to try to elaborate on these points. And hopefully by the end, it makes a compelling case for how we should think about Black history's promise. So on the meaning of race, first I want to provide some ground for understanding what I mean when I say race. The entire enterprise of Black history hinges on how we engage this word and the word Black or Blackness. And the antebellum Supreme Court case of Dred Scott v. Sanford offers a clear view of the function of race in the construction of American law and jurisprudence. That case is often cited as evidence of the boiling tensions between the sovereignty of free states versus slave states and the juridical instantiation of non-citizenship for Black people in the United States. But for our purposes, I want us to linger on the words in this decision in order to ascertain what it says regarding the meaning of race and the meaning of Blackness. So in determining whether Dred Scott was a free man because he had been taken to free soil by his owner, the court made pronouncements about Scott's status under the law. This was a question of ontology, which is simply the study of being. The court was deciding not just whether Scott was free under the law, which is a metaphysical question. They were determining the status of Blackness in the modern world. What does it mean to be Black, which is the ontological question. So we're going to take a look at their words. Interpreting the intentions of the signers of the Declaration of Independence, the court in Dred Scott v. Sanford wrote, on the contrary, Negroes were at the time considered as an inferior class of beings who had been subjugated by the dominant race, and, whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power and the government might choose to grant them. The statement's pretty straightforward. The Supreme Court understood and also inferred that their political predecessors also understood that the condition of Blackness was one of an inferior class of beings, related to the dominant race by way of subordination. White and Black constituted different classifications in how they understood what it meant to be Again, the ontological question, human. But there is no need for us to try to parse out the implications of these words because the court was very explicit. Writing, they had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. They not only seized them on the coast of Africa and sold them or held them in slavery for their own use, but they took them as ordinary articles of merchandise to every country where they could make a profit on them. So here the court establishes the relationship between whiteness and blackness, the dominant race versus the subordinate one. A class of men with a right to own a class of property. None of the attributes that constituted what it meant to be a human subject under the law applied to the Negro, who was so poorly developed in their minds that slavery was considered a benefit for them. The Negro was this geologic resource, something to be extracted from the land, Africa in this case, and used in the interest of capital. I'm going to make a slight sidebar here to say that there's a lot to think about when the court makes this relationship explicit. It provides some evidence of how we should think about the relationship between race and capitalism in history. And that's not the topic for today, but scholars have now written plenty about how the history of capitalism is inextricable from racial slavery, that in fact the idea of a free market was founded upon the trade in human chattel, and that there's never existed a free market outside of racial exploitation and, importantly, governmental protection and regulation of such exploitation. So while I will be thinking specifically about the history of housing in the US and the meaning of that in the law and in the talk today, we could spend hours exploring the historical co-construction of capitalism and racism as well. Historically, I think there's enough empirical evidence to say the two have gone hand in hand, where the former has always depended on the commodification of certain types of people. That is, capitalism has never existed without racialization. But this idea of commodifiability remains important for our effort to define race and to understand how race came to be. Let's look at one final passage from the Dred Scott decision at length. The Declaration of Independence then proceeds to say, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among them is life, liberty, and the pursuit of happiness, that to secure these rights governments are instituted, deriving their just powers from the consent of the governed." Now, importantly, the Declaration of Independence doesn't just claim that all men are created equal, it also defines what it means to be in that category or class of people called men. To be human means to be divinely endowed with rights, such as life, liberty, and the pursuit of happiness, and it's the role of government to protect those rights. Quite plainly, as we saw on the previous slide, not only did enslaved people not have such rights, but neither did emancipated Black people either. The Supreme Court stated that the only rights Black people had were not divinely given, but rather whatever the dominant race might capriciously allow. But I don't actually need to keep interpreting that for us because the Supreme Court was not ambiguous on this point. They continued, "The general words above quoted would seem to embrace the whole human family, and if they were used in a similar instrument at this day would be so understood. But it is too clear for dispute that the enslaved African race were not intended to be included and formed no part of the people who framed and adopted this declaration. For if the language as understood in that day would embrace them, the conduct of those distinguished men who framed the declaration would have been utterly and flagrantly inconsistent with the principles they asserted. And instead of the sympathy of mankind to which they so confidently appealed, they would have deserved and received universal rebuke and reprobation. Yet the men who framed this declaration were great men, high in literary achievements or requirements, high in their sense of honor, and incapable of asserting principles inconsistent with those in which they were acting. They perfectly understood the meaning of the language they used and how it would be understood by others, and they knew that it would not in any part of the civilized world be supposed to embrace the Negro race, which, by common consent, had been excluded from the civilized governments and the family of nations, and doomed to slavery. They spoke and acted according to the then established doctrines and principles, and in the ordinary language of the day, and no one misunderstood them. For the Supreme Court, there was no room for equivocation on the matter. The idea of common humanity was not constructed with the idea of the inclusion of all so-called races. The idea of common humanity was constructed against the condition of Blackness. To be Black was to have an absence of humanity. This was and remains the function of race, to delimit what groups are included into and excluded from the category of human and its attendant rights, privileges, and values. So race is not a biological status. It is not the color of your skin. Your so-called race is your political condition in the modern world. Does the law, both in word and in deed, truly consider you to be human or not? Now, this is perhaps the most important intervention of Black studies, from my view, into the social sciences, humanities, the law, STEM, including the discipline of history itself. Because oftentimes we find ourselves in a discursive trap with proclamations like, "We are all human." Without belaboring the point too much longer, I would like to impress upon the room that the lesson we should remember about race is that if we intently look at its history and theorize it, what we learn is that we are not all human, even if we are all of the same Homo sapiens species. Humanity remains a legal and political category, a metaphysical question, that gets conflated with the idea of the human species as if they were the same thing. So we have two ideas of the human operating at the same time. They get conflated, and the biological fact that yes, we are all human comes to obscure the political fact that no, we are not all considered human in this world. If humanity were so indivisible, then Black people would not have been eligible to become chattel. And if humanity were merely a biological truth, to be simply human by birth, the Supreme Court could not, with all that confidence, proclaim that the signers of the Declaration of Independence's plain understanding of who were men did not include the Negro. They knew this, and so did their contemporaries. So that definition of race is very important for how we're going to move forward into part 2, the lawlessness of the law and Blackness as the state of exception. Unfortunately, race is often thought of as being merely a signifier of the color of your skin or your geographic ancestry. And so much of what we do as scholars and legal practitioners and policymakers is to treat race as a simple fact of identity, rather than a violent historical imposition on our, capacity to become whatever we could dream if we were unencumbered by the violence of race. Of course, critical theorists have argued that this is an inextricable problem in Western society and under modern law. The law, folks like Derek Bell, Mari Matsuda, and Kimberly Crenshaw, among others, have argued, is political. And because race was historically foundational to the modern West, its epistemology, including law as a form of politics, are always racial. Now, prior to the advent of critical legal studies, and unfortunately it's still true today, I think, for plenty of us who are lay people who don't practice the law is most commonly understood as a set of neutral statutes that standardize the administration of justice, resources, and political power across the citizenry. And indeed, the narrative of democracy that we're taught is that the law is taught to serve two functions. The first is to make us all equal, and the second is to do so by placing power in the objective letter of the law rather than in the hands of a sovereign figure, like a king, a queen, or a governor. Because those sovereign figures might arbitrarily make decisions regarding economy, politics, resources, and so on. The legal scholars and critics of the law have upended this faith, demonstrating that the law establishes spatial and temporal jurisdictions for itself, places and times where the law applies, and in doing so also establishes the state of exception, times and places where the law can be suspended. Where the law is suspended, the sovereign decides what is allowed to happen, and thus lawlessness is foundational to sovereignty, but sovereignty itself is constructed by the law. That is, there's a fundamental paradox in the establishment of the rule of law, but it only appears to be a contradiction. The law must allow for its own exception. And I know that's a lot of words, so I thought maybe I need to do a graphic representation of that might help pare it down. So a lot of this is Giorgio Agamben's theory of the state of exception and the law. And he starts with the concept that Western law and jurisprudence begins with a certain kind of assumption that the world and the universe are naturally in a state of chaos. This is the state of nature. The purpose of the law, as we just saw in the Dred Scott decision within the Western world, is to establish a kind of zone of protection from the state of chaos, to protect people's rights and to ensure that they can live freely and securely. This would be the law of jurisdiction. But in creating a jurisdiction, the law also implicitly establishes a state of exception or a zone of indistinction, where the rule of law itself is ironically suspended by the law, where authority figures who are made authorities under the law are granted some forms of sovereignty to make decisions about what to do in states of emergency. In more benign examples, we can think about how during a natural disaster like a hurricane, a governor might say, we're in a state of emergency, and there are certain rules about governance that are suspended in order to make decisions. But we also have other examples of the state of exception not being so fantastic or benign. And those include examples of the tortures of prisoners at Abu Ghraib or Guantanamo Bay, because they're not considered a part of the US physical jurisdiction, or qualified immunity granted for police officers, right? The ability to act outside of the law and not be controlled or contained by it, basically being granted street sovereignty. So this state of exception is very important because it dovetails with our understanding of how race has worked in American history. We can turn to the 1920s in Southern Florida to see the law's exception at work and its predictable racial contours. So I'll provide a little background here. White speculators began to seize land and build property in South Florida at a rapid pace at the close of the 19th century. And by the 1920s, the region's population increased by over 400%. So prior to this, you had Black, white, and Indian populations in South Florida, but it was sparsely populated relative to what it would become. There was no need for Jim Crow prior to the early 20th century. And then in 1921, the city ratified a new Jim Crow charter that would legally cement residential segregation in the city. Under the Chamber of Commerce, an all-white, all-male realty board enforced specific provisions on the charter, arguing that in order for the city to flourish and to continue attracting investment, it needed consistent land use. And in particular, the consistency was that there would be no integration. That meant limiting the freedoms of certain individual white landowners who might want to buck the trend of segregation and open up housing opportunities for Black residents near white homes. For them, an enduring structure of segregation would guarantee both peace and progress, keeping racial violence in check by limiting social interactions between white and Black people, reminding Black people of their place in the social hierarchy as supplements to the well-being of white folks, and attracting investment. Out of this legal arrangement came projects like George Merrick's City Beautiful, which would raise and develop what is now the city of Coral Gables, built and marketed and maintained as for whites only. And today, Coral Gables' population is still about only 3% Black, and I don't believe that's a historical coincidence. Then in September of 1926, Miami and its booming real estate market were brought to its knees. Winds came at 140 miles per hour, and 5 feet of water covered a great deal of Miami Beach. Coconut Grove, where some of the wealthiest investors had built their homes to enjoy the beauty of Biscayne Bay, was hit with 15-foot waves. The storm killed about 400 people and injured hundreds more. A month later, another storm hit, devastating the area again and bringing South Florida's growth to a halt. Ironically, Colored Town was spared from the worst of these storms. White people had relegated Black people to this western side of Miami, furthest away from the gorgeous views of the ocean, but also protected from its wrath. The winds did considerable damage to the poorly constructed housing in Colored Town, blowing out windows and taking off tin roofs of the wood-framed dwellings, and swelling the unpaved streets with mud. And so when the storm passed, of course, the folks who lived there began working to repair their homes. What happened next reveals that Jim Crow was never really about the separation of the races so much as it was about structuring a certain kind of intimacy between white and Black people. And by a certain kind, I mean one in which white people could access and exploit the caloric capacities of Black people's bodies to siphon Black people's energy for the production and maintenance of white life. And here I'll quote from Nathan Connolly's A World More Concrete at length. That's when the truck came. Wilhelmina Jennings, a Miamian with Bahamian and American parents, only a young girl at the time, remembered how armed white National Guardsmen drove their personnel truck into Colored Town in the hour following that September storm. South Florida's beachfront was an absolute ruin. The storm had reduced most of the hotels and boutiques on the multi-million-dollar coast to a heap of beams, shattered marooned yachts, and soaked furniture. To meet their immediate recovery needs, the Dade County and Miami City Commission issued a Negro conscription, because we're in a state of exception. And it was an order that forced all Negro males of workable age to help clear debris on the white side of the color line. They were going through the Black areas, getting the Black people to go help clean up what happened on the beach because the beach was torn up. So the guardsmen ordered Wilhelmina's grandfather, Shaddy Ward, and his three sons to get off their roof and climb in the back of the truck with a dozen other colored people already impressed in the service. A proud man of property that clearly needed tending, Ward initially held his ground, but he and his sons eventually cooperated when armed whites began, quote, getting kind of rough. Once on the truck, Shaddy heard the shouts of his daughter, Mabel, coming from down the street. He looked to see guardsmen grabbing her out of one of his smaller family houses. Despite the apparent order to just grab men, they were making women and men. Anybody who was in there come. Jennings remembered of Mabel. She refused to go. College student, she wasn't going. She knew her rights. In short order, Shaddy and his three sons jumped off the truck and, through the mud and over the debris, sprinted down the block to assist Mabel. Several National Guardsmen gave chase. In the confusion, the dozen or so colored people on the truck jumped off and fled. Bedlam broke out then. Members of the Ward family retreated into their home with two guardsmen boxing them into the central hallway of the house, one at the front door, and one at the back. According to Jennings, one soldier had discharged his rifle and a single bullet passed through Shaddy's leg and both of Mabel's legs. It then, however remarkably, grazed the leg of a second National Guardsman and that of one of Shaddy's sons. Reports in the New York Times described a shot-for-shot gunfight between the Guardsmen and the two unnamed Negro men who arrived from Nassau but a short time before. Other reports described some 2,000 colored men and women gathered around the fallen Guardsmen bearing arms and shouting. To restore the prevailing racial order, police, deputy sheriffs, and other guardsmen, according to reports, began clubbing scores unmercifully. Officers arrested some 20 Black people who were reportedly heavily armed, and the remaining guardsmen loaded up the truck with all the wounded, color and white, and drove away. The next day, the aftermath of a conscription order was felt elsewhere. Reports came in of 3 Negroes lynched 10 miles from Miami, their bodies perforated with bullets and burned. Isn't it ironic that Black people were accused of looting on Miami Beach and lynched for it, but when their bodies were being conscripted to repair the whites-only sections of the city, this wasn't considered a form of looting? As we saw in the case of Dred Scott, the Negro was historically and legally constructed as occupying a zone of indistinction. Not human, not animal, somewhere in between, but definitely subordinated to the dominant race. As a place outside of the law where white people had the equivalence of sovereignty to determine to what extent Black people would be allowed to exist. Despite that Dred Scott was a 19th century case, we are here in the 21st century asking the same questions and enduring the same problems. The Supreme Court just allowed Alabama's racial gerrymander to stand. In 1987, McCleskey v. Kemp decided that patterns of racial discrimination and capital punishment do not constitute evidence of discrimination for any particular individual, thus denying them standing. It has made Roe v. Wade essentially irrelevant, and it invented qualified immunity in Pearson v. Ray in 1967, and did so out of thin air. That list can go on and on. Empiricists will often point out that Black people are no longer relegated to the backs of buses, though, that the Voting Rights Act gives everyone access to the ballot, that if you can afford to buy a home in a neighborhood, no one can legally bar you from doing so. And these are evidence for these empiricists of change over time, and particularly of improvement. And I don't disagree with that the material conditions of life have changed in significant ways for Black people. However, we're still mourning the loss of Breonna Taylor and newly mourning the loss of Amir Locke. Black people who were slaughtered in their homes under policies enacted during the bipartisan war on crime, which invented SWAT, saturated police departments with money, and built a public campaign with the express purpose of targeting low-income Black urban neighborhoods for suppression. That is, empiricists can point to material changes, but they can't argue convincingly that there has been a structural change that has redefined what it means to be Black. The ontological question comes back. As Toni Morrison wrote in The Bluest Eye, I learned that the change was adjustment without improvement. To be Black in America continues to mean being held responsible under the law, but being guaranteed no protection by the law, or better yet, no protection from the law and its makers. English scholar Saidiya Hartman describes the situation in her groundbreaking book, Scenes of Subjection. She asks, what happened after formal emancipation and the ratification of the 13th Amendment? Did the meaning of race, did the status of Blackness become unfixed to the condition of slaveness? She quotes from Carl Schur's 1865 Report on the Conditions of the South to the Freedmen's Bureau, and her answer is no. Schurz wrote, the emancipation of slaves is submitted to only insofar as chattel slavery in the old form could not be kept up. But although the freedman is no longer considered the property of the individual master, he is considered the slave of society. Hartman notes that when Black people were emancipated, the law remained a pivotal mechanism for ensuring they remained unfree. They were free to make decisions about their lives, but under vagrancy laws could be imprisoned and leased out to work for no pay. They were free to work, but under contracts that spawned debt peonage, which is just economic slavery. And Hartman also argues that the law enslaved them in a different kind of way, not just physical or economic bondage, but also in terms of how they policed themselves, finding themselves newly burdened under emancipation and by the law. Rather than being given autonomy, they were being grafted into a new political economy, and because they were ostensibly free, this would be regarded as a consensual relationship. But emancipation and freedom are not the same things, and consent requires equal footing and mutual understanding. And in no way can the circumstances of the formerly enslaved in 1865 and 1866 be construed in those terms. As Hartman writes, emancipation announced the end of chattel slavery. However, it by no means marked the end of bondage. Free people were burdened, responsible, and obligated, and to be held responsible was to be blameworthy. In this respect, the exercise of free will, quite literally, was inextricable from guilty infractions, criminal misdeeds, punishable transgressions, and an elaborate micro-penalty of everyday life. And we see this grow over the course of the early 20th century. Historian Khalil Gibran Muhammad in The Condemnation of Blackness demonstrates that it was during the so-called progressive era, which coincides with the establishment and elaboration of Jim Crow, that we witness the scientific, philosophical, and political association of Blackness with criminality. So Black as slave in the 19th century becomes a Black as criminal in the 20th century. It seems to me that Toni Morrison was right. We witnessed adjustment without improvement. In summary then, for this section, if we understand race as much more than a signifier of identity, but rather as the manifestation of racism, if we understand Blackness not as who we are, but rather the historical consequence of anti-Blackness, we can commit more fully to a structural rather than a so-called empirical analysis of history and the law. History, rather than marching toward fuller democratic inclusion, is revealed as a set of stories. And we tell these stories about ourselves. We tell these stories to ourselves about the past in order to make sense of the present. But often, in doing so, we make excuses for ongoing inequality in the present. The narrative arc of so many history texts is things used to be worse, things are improving, and things will eventually improve. And the law, rather than being the mechanism that makes us all equal, has been racially inscribed, refusing to recognize the historical situation that we have not all been equal and that we remain unequal. As Saidiya Hartman writes, the law's stipulation of abstract equality, that is, the writing and administration of the law as if we are all equal, produces white entitlements and black subjection. The fragile as if equal of liberal discourse inadequately contends with the history of racial subjection and enslavement. Because the texture of freedom is laden with the vestiges of slavery, and abstract equality is utterly enmeshed in the narrative of black subjection, given that slavery undergirded the rhetoric of the Republic and equality defined so as to sanction subordination and segregation. In short, at the level of the structure of American society, Black people occupy a zone of indistinction, held responsible by and under the law, but not guaranteed protection from the vagaries of white supremacy. The law considers us equally liable for punishment, but does not make us equal parties in the holding of power. This will get us into the final part, employing Black history for a structural critique of history, liberalism, and the law. So whether the argument is compelling to you or not at this point, the fact remains that Black people in America still suffer from discrimination in ways that are allowable under the law, or have been decided by the courts to not be evidence that is admissible or grounds for standing to pursue redress. Housing has proven to be an intractable domain for the maintenance of racial separation, particularly the hoarding of resources like clean air, fresh infrastructure, healthy schools, grocery stores, access to efficient public transit, and so on. We know, and we've known for decades, that Black-owned homes are appraised below their value, that Black people have had to pay excessive premiums to buy into predominantly white neighborhoods, that the cost of living is disproportionately burdensome on working class people, who are also disproportionately Black, that school qualities vary by neighborhoods and the historical circumstances out of which those neighborhoods came into being, and so on. These are undeniable, and Black people are well aware of them and so have historically sought physical and metaphysical grounds for securing better lives for themselves, namely by way of carving out places of inclusion for themselves into the law, such as with the Civil Rights Act or the Voting Rights Act, and by pursuing property ownership in order to build wealth, secure economic freedom, provide better lives for their children, but importantly to establish themselves as members of civil society by becoming tax-paying citizens. And their residential choices haven't been predicated on living next to white people, but on having the same resources that white neighborhoods have historically had. As Dorothy Caesar said, we had no interest in being neighbors to white people. We were only interested in finding a home we wanted. And this is the house we wanted. The Caesars family story didn't end with the arrest and conviction of Carl Davis. Indeed, the bombing of the Caesars residence in Riverside Terrace presented a crisis for Houstonians, Black and white. Up until this point, Houston had imagined itself as a peaceful Jim Crow metropolis, and this tested its residents' commitment to liberal individualism. Prior to the bombing, Black Houston leaders, with the help of Carter Wesley's Houston Informer, a Black-owned newspaper, amplifying their concerns, argued that Shelley V. Kramer had settled the issue of residential segregation and had affirmed the individual right to property ownership, unrestricted by color. However, as legal scholars Carol Rose and Richard Brooks demonstrate, the legal precedents upon which Shelley rested slyly upheld the free sale of individual property, while implicitly permitting white owners to exercise a group property right, exclusive white residency in the neighborhood as a whole. Indeed, residential desegregation was never a legal or moral mandate. If Black people had gained the right to move in, white people had certainly maintained their right to leave and to close ranks. Thus, at first it seemed as if the Caesars had won a solid victory, and indeed they were part of an early trickle of Black Houstonians who found much more desirable homes in Riverside Terrace and Riverside than was available in much of Third Ward. However, as white residents accepted that Black people would become permanent residents of the area, they abandoned the neighborhood in droves. Between 1960 and 1970, Riverside Terrace grew from 74% Black to 95% Black, and Riverside astoundingly transitioned from less than 1% Black to 70% Black during the same decade. I don't have Riverside on this particular map, but the squiggly line at the bottom of Riverside Terrace is a river. The neighborhood on the other side of that river is Riverside. That is, while the Caesars and others experienced a quantitative change in their capacity to buy property where they wished, the 2 decades immediately following Shelley would demonstrate that the qualitative relationship between whiteness and blackness, between white governance and what I theorize as black spaces, had not been altered. In 1959, city administrators and the Texas Department of Transportation altered plans they had put together for the construction of Highway 288, the South Freeway. Those plans had been constructed in 1953, and although the original plans for the freeway would have cut through some of Riverside Terrace, the new plan was developed to avoid an oil field and be situated closer to development in Southeast Houston. Development in Southeast Houston that was newly developing because white folks were fleeing. So while it would displace nearly 300 families after construction began in 1968, the supplementing of the building of suburbs was an important priority for the city. So at first glance, here we have where the highway is going to cut through on the highlighted line. So at first glance, it may have seemed as if the South Freeway was not very destructive to this increasingly Black Riverside Terrace and Riverside neighborhoods. While Riverside lost about 900 residents between 1960 and 70, Riverside Terrace gained about the same number. Home vacancies in Riverside Terrace fell and maintained at 14% in Riverside between 1950 and 1970. However, as historian Kyle Shelton notes, I-45 and South Highway 288 and the State Highway 288 demanded the removal of over 2,000 homes in Greater Third Ward, and Black residents, quote, absorbed a great deal of the impacts of the construction, losing what some families had fought for decades to achieve. Curiously, the population count in Riverside, it did not fall as a result of this destruction. But the seeming paradox of residential demolition unaccompanied by a demographic decline is solved by a very simple mathematical calculation: the changing composition of the housing stock in the neighborhoods, where in Riverside Terrace, the share of single-family homes fell from 69% to 39%, and in Riverside from 78% to 53%. So although it would seem that low vacancy percentages indicated that the neighborhoods remained desirable between these 2 years within this decade, this was also due to the increase in the number of housing units per structure as opposed to a constant number of housing units. So although vacancies decreased from 12 to 9% over the course of the decade, the number of vacant structures actually increased by 100, from 314 to 417. This was a consequence of the ripple effects of highway construction. Together with blockbusting efforts by realtors, highway construction precipitated the transformation of single-family houses in the Riverside area into multi-family units, with a concomitant increase in transients and less incentive for homeowners to maintain their properties. As was true with the construction of I-45 for Houston's 4th Ward and I-10 for Houston's 5th Ward, Black residents who could afford to flee the path of destruction abandoned many homes adjacent to the highway, and that changed these neighborhoods from vibrant, livable space into a shell of its former self. White flight and municipal practices thereby produced in Riverside another Black space in Houston's inner core, a neighborhood that had once been of peak desirability for its location, its stately homes and small mansions, its large lots, beautifully tree-lined streets, and easy access to the central business district and medical center, all transformed into a kind of void, a negated nothing. The Caesars house would have been demolished for the highway had it not been taken from the ground and transplanted in South Houston. Home vacancies, overcrowding, noise, and increases in nightlife-related disturbances would quickly come to trouble some pockets of Riverside. And white property owners who had fled, but still owned property there, turned into rentals, neglected the property, quote, waiting for the commercial takeover of the community. The legal dignity apparently granted by Shelley was ephemeral, and Black Houstonians' right to own property was curtailed yet again by the social and material construction of this Black space. Indeed, liberalism would not guarantee Black people's absolute right to property, nor did it curtail white people's exercise of their long-standing group right to racial alienation. And so for the Caesars and so many Black folks, where this story is repeated here in Tampa with the destruction of Central Avenue, it's repeated in Miami with highway construction, Los Angeles, Oakland, Detroit, anywhere in the country, the American dream for these families unfortunately remained an empirical impossibility. So what now? I begin the talk with 3 questions. Did the Supreme Court's decision in Shelley v. Kramer change the structural position of Black people in American society? Does the law present opportunities to realize a more perfect democracy than the ones Black Americans have suffered? Does liberalism in its tenet of abstract equality have the capacity to make us all equal? And my answer to these questions, which is an argument, was no. And I believe, unfortunately, that the circumstances of Black people, certainly in the domain of housing, but also in education, business financing, dating and marriage markets, healthcare, and so on, continue to indicate a structural distance from the power, resources, and prestige that the nation grants whiteness. This is not to say that individual Black people cannot ascend to higher social ranks or achieve great wealth, but that A, structurally, Black people remain at the bottom of America's hierarchy, and B, regardless of an individual Black person's achievement, they have no way to opt out of being Black and thus being at risk of the implications of being structurally positioned as such, of being at risk of racial profiling, police violence, discriminatory appraisals, and so on. All of these things that happen under the authority of the law, but outside of the regulation of the law in the state of exception. My argument should also not suggest that the path forward is merely greater inclusion by way of the law. So when we think about history, right, when history is exposed through a Black analytic, what we see in this historiography are narratives that attempt to rationalize, that is, explain away Black suffering. As historians, we typically and implicitly ask, how did we get here? And in the case of recalcitrant patterns of racial segregation in housing, historiography has offered a number of explanations: white flight, suburbanization, highway construction, deindustrialization, racially neutral economic processes of supply and demand, Black self-segregation, and so on. But my own analysis of the historiography and my independent research demonstrates that any of these may be true for any given local history, but none of these factors have been necessary. Black people are not segregated because of these reasons that historians have offered. Rather, these are mechanisms by which segregation was maintained. Indeed, when history is modified by a critical understanding of Blackness, we see that history as an academic enterprise has functioned more as theodicy, an explanation of suffering that allows the world that whiteness has invented to remain redeemable in some way, sometime in the future. It is this fantastical hope, grounded in faith and not in empiricism, as historians claim, that the anti-Black world can be saved by way of its own tools, that the arc of history bends toward justice, that democracy is necessarily an unproblematic destination for freedom, and that we are, in the end, on the right path, even if we stumble. The simple, disheartening reason Black people are segregated is because the social structure of this country was founded in anti-Blackness and remains anti-Black. Thus, the law may provide avenues for adjustment, and indeed it has. I don't want to discount the very significant work of civil rights attorneys, legal scholars, and sober judges who have made our lives more livable today. But if there had been structural improvement, why must we still echo our enslaved ancestors declaring to quite incredulous worlds that Black lives matter? But my goal isn't to leave you disheartened. It's to encourage a critical stance toward the metaphysical tools that we have often used in service of Black liberation, tools like history, sociology, psychology, and the law, to consider what we can accomplish with them and to recognize their limits. In doing so, we see that they are a means by which we understand and negotiate the world, but that they are not necessary, that they are not the endpoint of what is possible. So even as we fight using these tools, drawing on the strength of folks like Jack and Dorothy Caesar, like the Black Miamians we discussed today, like Dr. Ocean Sweet and his wife Gladys in Detroit, who were in an earlier version of this talk, we must also be imaginative. We have to invent ways to think in contradiction to accepted knowledge. This is what Derek Bell encouraged by introducing counter storytelling and allegory to legal scholarship. It's what Saidiya Hartman has done by inventing critical fabulation as a method for writing about the impossibility of writing Black history. Through our ingenuity and creativity, we can push Western thought to its limits. And then once there, carve out alternative visions of how our world can work, how it can look, and how we can relate to each other. We don't merely want the inclusion of Black people into an exploitative structure where people are overworked and undernourished, where poverty is normal, where criminalization and incarceration remain the solution to social problems, where Black people's children go to white schools to be indoctrinated in anti-Blackness, or where white schools still exist at all. We don't want a world where the two-party system ensures that Black people can vote, but that they don't get representation. The great poet and thinker Tony Bambara once wrote, "What are you pretending not to know today, dear?" And I've written this on mirrors throughout my home. It's a question that I ask myself every day. I think we've long pretended not to know that Black history is, in an important way, and I think a productive way, an abyss. We often hear the refrain, Black history doesn't begin with slavery, but I would argue, in fact, it does. Blackness was a white invention. The varied peoples of Africa would not have identified themselves with this language. They didn't track the concept of race, nor imagine this ontological fissure dividing our species into humans and less than humans. That is, Blackness is a relatively recent historical construct, and it is foundationally tied to racial slavery. This should not dishearten us, nor should it make us forget that there is an African history that precedes slavery. But if we stare into this abyss, I think we can finally say that the world that we have inherited has a point of origin. And the whole point of recognizing this, I think, is to finally see that it means the world that we have inherited is not necessary. That humans have lived without race and without systems and structures that allow race to corporealize in white bodies or Black flesh. The lesson of Black history is that we can inaugurate a new world. But the other lesson is that such a world will not be inaugurated simply by way of Western metaphysics, not by the tools of history or the law. And so our duty is not to uphold this world, not to protect democracy or liberalism or individualism at all costs, but to love ourselves at all costs, even into the end of the world as we know it. This, for me, is the legacy of our ancestors, the meaning of Black history, and it's the power of hope in the bowel of the slave ship. For me, this is the pessimism and promise of Black history. Thank you all so much.
Thank you so much for that wonderful presentation, Dr. Ponton. I'm going to go ahead and help my colleague out, Professor Hardrick. We're having technical difficulties, and then nowadays, we're ready for all of it. So no problem. Do we have any questions in the chat? I did not see any on my end, and I wanted to give guests the opportunity and participants to ask their questions while we wrap up here in just a few minutes.
Are you able to hear me?
Oh, try it now. Get a little closer.
I'm
Get
just
a
double
little
checking.
closer. No,
Yeah, you
nope.
just handle it.
Your mic is like, no, you have me working overtime. So we have a comment from Professor Neville Yu. Professor Neville Yu, you're used to this. Maybe you want to go ahead and unmute?
Yes, I first want to commend you for what I thought was an outstanding presentation for several reasons. But I just wanted to pinpoint my one concern about what you said, because that goes against the oath that we take as lawyers to suggest that our job is not to protect democracy. And as a historian, no, it's not. But as lawyers, I beg to differ. that the stories that you told and the approach that you used in sort of synchronizing and showing relative value in storytelling as well as in using actual data, I thought was brilliant and also captivating. And it is those stories you see that motivate most of us as lawyers, generally Black lawyers in particular, or at least for me, I won't speak for everybody. Those are the things that motivated me to want to be involved to try and make this thing called democracy that historically has not been uniformly available. That's the reason why I do this. And of course, everyone here who knows me well knows that I'm particularly enamored with your discussion because I'm a real estate lawyer and have been intimately involved, you see, in trying to right some of the wrongs that you addressed. So for so many reasons, you have captured my heart. Secondly, I wrote an article called Black Women in Property, 1800 to 1850, Black Women as Property. And in that article, I talked about the stratification that exists that you touched upon. And under different circumstances, I'd like to talk to you about that because I chronicle the distinctions that were made even then. And of course, it's evident in the title, but it's really important to look at the stratification as it existed simply from a woman's perspective, let alone Black folks generally. But I was absolutely enamored for so many reasons. And thank you so much. It's fabulous.
Thank you. Thank you so much for that comment. I am looking forward to reading your piece. And on the issue of gender, right? That complicates things. And by complicate, I don't think that I mean makes it more difficult. I think that it opens up even more opportunities to see how insidiously race works, right? When it gets refracted through other lenses such as gender or skin color or sexuality or socioeconomic background. So thank you for that. There was a version of this talk that spent a bit more time talking about gender, um, and it's always a sad thing when I can't do that as much as I like. And then on the issue of right protecting democracy, I take your point. And like what two of my most favorite historical figures are Thurgood Marshall and Fannie Lou Hamer. And those are two folks who fought so hard and painstakingly and put their lives on the line in service of creating a better democracy for this world. And I think about like so Thurgood Marshall obviously on the legal side of things is making by the end of his career a good number of strong dissents about how the court is dealing with issues of affirmative action and of equal access. He's saying, well, we made these decisions before. These were structural issues. We were on the right path. And now we've gotten back to this sort of this individualist approach to how we should redress these kinds of situations, which didn't result in redress at all. And so I honor right his continued struggle for making American democracy better in the same way that I honor Fannie Lou Hamer's work. From her perspective, I see even her ability to marshal mutual aid organizations to create the kinds of things that exist outside of the purview of government in order to provide food, in order to provide access to the ballot for people, right? So my argument isn't that we let all of that go, or that we don't value it, or that we don't value the work that any of you do. I hope that's not how it came across. But that at the same time that we do that, we hold still a very critical eye towards what it means to maybe sacrifice some things in the name of democracy. To say so, and I'm gonna end my response here. I think so.
Yeah, because we could go on and on, and I don't want to go on and on, but I intend to because I'm gonna get in touch with you. There's so many things I want to comment on, but I'll hush because people here know that I can go on too long. I'm done.
But one of the questions that I get sometimes when I talk specifically about my own research and how I think about its implications, a question I get is, well, what do we do now? If we know that we have this long history of housing segregation and it's been a problem, or even educational segregation and it's been a problem, like what do we do? And there are two answers, I think, or three answers maybe. We do nothing, or two, we seek greater inclusion, but we've seen what that looks like. But we've had over 50 years since Brown v. Board. Or we reimagine what this whole political arrangement we have looks like. If we're supposed to be consenting to be governed, but there's an unequal access to power, then there's really no room for consent. So what does that mean? Does that mean that other folks might have to give up some rights in order for us to get to that better place? Does that mean that that's a betrayal of democracy? So if I say, for example, that I want my kids to never have to worry about attending a segregated school, that also means that white families won't get the choice to send their kids to segregated schools. And in some people's views, that's going to be anti-democratic. Maybe from my view and your view, that is democracy. That is us finally consenting to be governed together, especially those of us who have been historically without power. But for other folks, they will see that as an attack on democracy. And so that's sort of my approach. Like we're critical of what we mean when we say democracy.
Thank you so much for your question, Florice Nipple.
I love that. Thank you too. Thank you.
I know you have so many, but I did get a few in the chat. And I also did have a raised hand. Diane, would you like to go next? I don't know. There's a raised hand that I can see, but maybe I missed it. Oh, are you there?
Yes, but I must have accidentally raised my hand.
No,
I'm sorry.
problem.
I'm sorry.
Well,
I didn't know it. I didn't know it was raised. I'm sorry.
It's okay. Well, glad you're here anyway. I did receive one question from Professor Hardrick. Okay, how do you think?
Are you able to hear me now? I can
Oh,
ask.
yay! Take it forward.
Sorry about that earlier, Dr. Ponton. I was an African American Studies major, so you're all in my wheelhouse with all this information. So my question is, there's a tax on CRT, there's the movement to end, pretty much discussing race in K to 12. And so if you're teaching college and graduate work with this kind of information, you had to give us all that background just to get to your thesis and your premise. What do you think, assuming this movement is successful all throughout the United States, how do you think that will affect college and graduate work discussing race and the impacts it's had on history and all these other topics as well?
Yeah, so one thing I want to do is kind of shout out my department at USF, which has always been very supportive of us doing critical work in the study of race and gender and inequality. In terms of what's happening for me personally, I feel very protected and very taken care of. But I have the same concerns that I think I see in this question about what it means for our incoming students being prepared to have these difficult conversations, and what it means for getting funding to do research for our graduate students. I think they are dampening people's willingness to speak out sometimes. I think that they are preventing us from, if we were having, adjustment without improvement before, then we're not even adjusting anything if we can't talk about the issues of race, if we can't have legal scholars at least be exposed to critical race theory and its implications for how you practice law, how you think about your own research and the kinds of articles you're producing, and how you can argue your cases. At the same time, I think what this history that we talked about today demonstrates is that people don't take this lying down. We find ways to resist. There are peaks and valleys, unfortunately. But I know that, so I attended segregated schools until I think my undergraduate school was also segregated in a different kind of way. But I attended, majority Black and brown schools my entire life until college, and had teachers of all races who cared about the students they were teaching. And whatever the state was mandating was one thing, but how they cared for us was a different thing. And as much as the state and its laws might have some sort of capacity to punish teachers for doing what I think is the right thing, it doesn't really have the arms or the length it needs to surveil all of that. So I think what we'll see is a kind of insurgency among educators who really care. And those educators, I think, won't be punished by their students or by those parents. I think they'll be encouraged by their communities. Um, but ultimately, these attacks on CRT are precisely an example, I think, of the thesis that I argued today as well.
Okay, I don't see any other questions in the chat, so last call for questions before we wrap up and release Dr. Ponton and all his wonderful information he's shared with us today. I know we're a little over time, about 2:14.
Oh, I'm happy to be here, so I'll show my account.
Okay, so like I say in my classes, seeing none and hearing none. I think we're going to wrap up at this point. I want to thank Dr. Ponton again for sharing his all that wonderful information, tying in the Dred Scott case, which is, of course, a great legal premise to start the argument on, especially for a group of lawyers. I want to thank all the folks who joined us today. So at one point, over 40 folks were in this chat, which is wonderful. And I'm going to pass it back to Daniela to wrap it up.
Thank you, Professor Hardrick. Thank you to all of you who joined in for today's fun, particularly students that are present today, members of the public, faculty, staff, President and Dean McGrath, as always, thank you. Thank you to the Diversity, Equity, and Inclusion Faculty and Staff Committee that made this also possible. Thank you to Terry Corella and Audra Foster. And thank you, Dr. Ponton and Professor Hardrick, for leading the discussion today. If you have any other questions for Dr. Ponton, he could be reached through the USF email, and that's how I was able to find him and invite him here today. Please join us back for the next community conversation, which will be March 3rd at noon, led by Professor Amanda Fisher, focusing on Women's History Month. See y'all later. Bye.